Good morning, everyone. The fines for the penalty of the final peace agreement of Colombia of 2016 could be considered a model for the world. But the transition to peace also needs social justice, which is far from being a reality in Colombia, the most unequal in the region since 2020, according to the Regional Development Index of Latin America. I'm Melba Calle, Meza, Doctor of Law for the University of Zaragoza in Spain and Professor of Constitutional Law at the University of Nueva Granada in Colombia. My presentation is titled Peace, Transitional Justice and the Purpose of Punishment, an analysis of the final peace agreement in Colombia. This is a short exposition. Introduction. On the 24th of November 2016, the final agreement for the termination of the conflict and the construction of a stable and lasting peace was signed in Bogotá by the Colombian government and the FARC-EP, Fuerzas Armadas Revolucionarias de Colombia, Ejército del Pueblo, the oldest legal armed group in Latin America. This final agreement created a special peace jurisdiction and transitional justice system that privileged restoration over traditional retribution. It also established the sanctions that can be imposed on those responsible for crimes committed in the context of the Colombian armed conflict, and that do not necessarily involve imprisonment, which have given rise to an open social and political debate. My research analyzes the traditional conception and the purpose of sanctions in criminal law in order to establish its difference with the sanctions and purposes of Colombian transitional justice and what this means for the achievement of peace. Here are three main points. Point one. Transitional Justice Act exceeded the retributionist limits of classical criminal law, but this does not mean that it's contrary to international criminal law or international human rights law. On the contrary, the signatory states of the Treaty of Rome are autonomous in the fulfillment of the obligation to investigate, judge, and sanction in transition processes such as the Colombian one. The purposes of punishment in transitional justice, unlike the purposes of punishment in ordinary criminal law, are wide and varied. As a whole, they comprise truth, compensation, restoration, the reconciliation of society, the consolidation of democracy, collective reparation, and reintegration. Besides, they have a reforming and communicating purposes that involve society as a whole and pursues to guarantee a peaceful social order. Point two. The penalties and the purposes of the sanction established in the final agreement and the norms that develop them make up an original justice system with fundamentally restorative purposes. The restoration is highly compatible with a last ratio of criminal law of the principle of minimum intervention, according to which the exercise of the criminal sanction power must operate when the other control alternatives have failed. Likewise, this transitional justice is more consistent with the principle of the social state adopted in the Colombian Constitution of 1991 because it favors the guarantee of the rights of the victims. Well, precisely, this transitional model does not exclude, but on the contrary, it contemplates a degree of retributive sanctions that contributes to achievement of the imperative of justice. Point three. The sanctions of the Colombian transitional system are suitable and adequate because they contribute to the achievement of peace and guarantee the right of the victim to justice, truth, and reparation. As combatants were not only encouraged to lay down their arms because their punishment of this model did not include jail, but also to tell the truth and assume the responsibility in the commission of serious crimes that would not have been recognized without negotiation and without the final peace agreement. Conclusion: that said, the solution to Colombia problem does not depend on either classical criminal law or transitional justice, because social justice is also essential. For this reason, the peace accord designed a comprehensive system that includes other points such as rural reform or political opening. In particular, it is necessary to really put an end to the closed nature of the policy that favored the corruption privileged minorities who have captured the institution and have appropriated public money with impunity, in addition to excluding and discriminating against the majority of the population, even in the pandemic. Because according to the UN, in Colombia, it went from 14 billion pesos in the power of 3 people to 26 billion pesos in the power of 5 billionaires. Well, 42% of the population is in condition of monetary poverty, of which 15% in extreme poverty. In Colombia, there is a secular awareness in the guarantee of social rights to health, to education, to work, also to freedom or to protest, all fundamental rights scheduled and protected at present. However, only through the effective guarantee of basic rights can solid foundation be established to banish political and social violence in our country, according to the Italian philosopher of law Luigi Ferrajoli in his study of the connection between rights and peace. Thank you very much.